Thank you for watching. I'm Susan and this is my colleague Jordan. We're both family lawyers at Michael Lynch Family Lawyers in Brisbane, Australia. We're going to shed some light on limitation periods in family law matters and why they're important. This discussion about limitation periods applies only to property settlement and spousal maintenance applications. It does not apply to parenting disputes. It's my view that understanding whether you have a limitation period in your particular matter is something you should focus on straight away after separation. It's important for separated couples to ask themselves, do I have a limitation period? If so, when is it? It's also helpful if you can diarise your limitation period so you don't accidentally forget it. Before we jump into the specifics of limitation periods and how they differ between married couples and de facto couples, it's important to understand the rationale or policy behind limitation periods, or put another way, why do we even have a standard application period? The Australian High Court has explained that limitation periods are not an arbitrary cut-off point. It's thought that it's in the interests of society as a whole that litigation between individuals is commenced within a fixed and well understood time period, so that once that time has elapsed, all concerned can carry on with their lives with certainty that they'll not be subject to litigation with respect to events that have occurred in the past. In saying that, the Federal Circuit and Family Court of Australia, Division 1 and Division 2, has the discretion to ameliorate time periods where the interests of justice require it. We'll discuss that concept in a little bit more depth shortly.
The relevant time period depends on whether the potential proceedings arise from the breakdown of a marriage or a de facto relationship. For a married couple, the time limit is 12 months from the date the divorce comes into effect. To clarify, that's not 12 months from the date the divorce was granted. It is the date the divorce came into effect, which is 1 month and 1 day from the date the divorce was granted by the court. This is set out in Section 44(3) of the Family Law Act. For a de facto relationship, the time limitation is 2 years from the date of separation. This is set out in Section 44(5) of the Family Law Act. Often there can be disagreements or uncertainty about the date of separation and when that was. Therefore, if there's any uncertainty, we strongly suggest obtaining legal advice so that you do not miscalculate your limitation date. The limitation periods do not apply in applications which seek only to vary or set aside existing property settlement or maintenance orders. We often get the question of what happens if my divorce was granted overseas? While overseas divorces can be recognised by Australian courts, it is not factored into the 12-month limitation period for property proceedings. If your divorce order was granted overseas and you have not been granted or made an application under Section 104 of the Family Law Act, then no limitation period applies as the divorce has not taken effect in Australia. As discussed earlier, the limitation period commences from the date that the divorce has come into effect in Australia.
So what happens if you find that you've missed your limitation period? So you haven't settled your matter via consent order or binding financial agreement, and you haven't commenced court proceedings. There is still an option to file an application for leave to proceed out of time. An application for leave to proceed out of time is essentially asking the court's permission for you to still proceed with your application in that court, and for the court to consider the orders that you're seeking about property settlement and spousal maintenance as compared to the orders sought by the responding party. If your matter falls into this situation, you should consider seeking legal advice about whether it is a good idea and beneficial to the particular circumstances of your case to make an application for leave to proceed out of time. Generally, the courts will take a position that granting a party leave to proceed out of time is a power that should be exercised liberally. Remember that leave to proceed out of time is a limited inquiry into the merits of a proposed claim. It's not a decision about whether the claim will wholly succeed or wholly fail, only whether there is a reasonable claim to be heard. There's a number of factors the court will turn its mind to when hearing an application leave to proceed out of time. First of all, it's the applicant who has to establish, based on the material that they've filed, that they have a reasonable claim. The court will also decide whether there's going to be any hardship to the applicant or to a child of the relationship if they don't grant the extension of time. It's also important that the applicant's court material explains why there has been a delay in bringing the application. The court's discretion to grant an application for leave to proceed out of time does not wholly depend on how much time has elapsed. For example, the number of days, months, or even years since the limitation period expired. For example, there are cases where a party's brought an application for leave to proceed out of time only 25 days after their limitation period expired, but the court decided not to grant leave. There's other cases where it's been 18 years since the limitation period expired and the court decided to grant leave. So it's important to seek legal advice about the particular circumstances of your case and whether or not you should make that application for leave to proceed out of time.
You can file an application out of time if you have consent with the other party. For example, if you and the other party reach an agreement and wish to enter into consent orders, you can still file an application for consent orders with the court. However, the court still has discretion to dismiss your application. However, in our experience, we find this rarely happens. If your time limitation has lapsed and the court does not grant you leave to apply out of time, then your matter may be dealt with under state legislation. If this is the case, then you will likely need to obtain legal advice from a property lawyer. We encourage you to obtain legal advice as soon as possible about when your time limitation period commences and when it will lapse. Again, you should also obtain legal advice if your time limitation period has lapsed so that you can obtain advice about how your matter can progress from here. If you have any questions or concerns about your time limitation period, then feel free to contact Michael Lynch Family Lawyers so that we can assist and provide you with advice.